Okay, you had been shot in this event?
Before this hearing even begins, we're dealing with a case that's already raising eyebrows. A defendant who claims he accidentally shot himself, not once, but multiple times, and now finds himself facing the harsh reality of deferred probation violations. What starts as a firearm mishap quickly turns into a serious courtroom reckoning involving bail jumping, absconding for nearly 2 years, and a judge who clearly has little patience for excuses. The big question is simple: was this a momentary mistake, or a pattern of ignoring the law that finally caught up to him? Stick around, because this case moves fast, and the consequences are very real.
Yes, I've heard narratives.
Okay, so he's got.
This moment is deceptively important. The judge isn't just commenting on the accidental shooting, he's assessing responsibility. Unlawfully carrying a weapon in a prohibited place might sound minor to some viewers, but legally, it's a third-degree felony in Texas. And notice what stands out: the defendant has almost no criminal history beyond this. That's usually a huge advantage in court. But here's the catch: probation is built on trust and supervision. Once a judge senses carelessness with firearms and decision-making, especially in alcohol-related locations, that trust starts to erode quickly. Do you think the judge is being lenient here, or already signaling that patience is running out?
And Ezekiel, do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this states that on April 6th, 2023, you, in this court, you were placed on 5 years deferred or unadjudicated probation for the third-degree felony of unlawfully carrying a weapon in a prohibited place. Is that true?
Yes, sir.
You know, it's a place that sold more than 50% of its supply of goods in alcohol-related items. First amended. Can we do number 7, bail jumping?
Sure, Dutch.
Okay. Allegation 7 states you committed the offense of bail jumping on or about March 5th, 2024 in Jefferson County, Texas. In Nacogdoches County, Texas, which is in violation of condition 1 of your deferred or unadjudicated probation order. Is that true or untrue?
Yes, sir. Yes, sir.
And then finally, number 8 states you failed to report to the Jefferson County Probation Office for the months of December 23, January, February, March, April 24, etc. Was he an absconder for how long?
2 years.
Hello.
This is where the case truly unravels. Missing probation appointments isn't a technical slip, it's one of the fastest ways to lose your freedom. The judge makes it crystal clear: supervision only works if the defendant actually reports. Being gone for nearly 2 years transforms this from a paperwork issue into full-blown bail jumping. And legally, the standard here isn't beyond a reasonable doubt, it's a preponderance of the evidence, meaning even one proven violation is enough to revoke probation. Let me ask you this: if reporting is the easiest rule to follow, why do so many defendants fail it?
Office, as this states, in violation of condition 4 of your deferred or adjudicated probation order. Is that true and correct?
Yes, sir.
So are you pleading true and correct to allegations 7 and 8 voluntarily, knowingly, intelligently, and because those allegations are true in this first amended motion to revoke unadjudicated probation filed on July 25th of 2024?
Yes, sir.
Do you understand that one or more violations of probation proven by a preponderance of the evidence or greater is enough to grant a motion to revoke probation like this one? Your probation can be revoked. You can now be found guilty and sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily to allegations 7 and 8 of this first amended motion to revoke unadjudicated probation. You understand and appreciate the consequences of pleading True.
Yes, sir.
Okay, what are we doing on it?
2 years TDC.
Do we have an agreement?
Yes, Your Honor.
I don't have a pen. An agreement's been reached here where your probation would be revoked. You would be found guilty beyond a reasonable doubt of this underlying offense of unlawfully carrying a weapon in a prohibited place, a third-degree felony, sentenced to 2 years in prison. Is that your understanding of the agreement?
Yes, sir.
And then we've got all these numbers here, plea of true to number 2, which is not what we did.
No, we can change that to 7 judge.
It takes 5 seconds after you put something on it for it to show up on the pen. We're getting these changed soon, they say.
The new ones are here, Judge, they just have to program them. So maybe it'll be under the Christmas tree.
Heard that. I've heard that since I was a young kid. I've learned there's some tomfoolery going on. Okay, so allegations 7 and 8 of the MTR motion to revoke probation first amended, you had pleaded true. To allegations 7 and 8 voluntarily, knowingly, intelligently. I find that supports the first amended motion to revoke unadjudicated probation in this case, to grant it by a preponderance of the evidence or greater, and your deferred or unadjudicated probation is hereby revoked for this third degree felony. Earlier in this case, you had pleaded guilty to this indictment voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here that finds you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that underlying the crime of unlawfully carrying a weapon on a prohibited place, a third-degree felony. I am following this agreement. You're hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. I'm showing you what's marked as State's Exhibit 1. Did you sign all of that? Understand it? Discuss it with your attorney? Is everything true and correct?
Yep.
State's Exhibit 1 is tendered into evidence without objection. Among other things, this states that you are waiving all rights of appeal. If I follow this agreement, I've done that, and you have no right of appeal. You will be given credit for all time you have served in accordance with this case. Do you understand what's happened today, sir?
Yes, sir.
Anything else?
No,
That is all. Thank you, Melissa.
In the end, this courtroom outcome reflects a hard truth about deferred adjudication. It's a second chance, not a safety net. By pleading true to bail jumping and failure to report, the defendant effectively sealed his own fate. The judge followed the agreement, revoked probation, entered a formal conviction, and imposed a 2-year prison sentence, a reminder that ignoring court supervision carries real consequences. This case underscores how quickly freedom can disappear when accountability breaks down. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.